I recently did an interview with the New York Times, and the interviewer was interested in doing a piece about marriages and whether or not immigrants are canceling their plans to get married abroad when they're both living together in the United States, or whether they are just continuing to get married abroad given all of the risks with the current immigration environment. And it got me thinking about doing a video about whether it's better to get married abroad or in the United States when you apply for your immigrant spouse to become a permanent resident. First of all, I can't really get into this topic unless I first explain the difference between adjustment of status and consular processing. I'll keep this short for those of you who already subscribe to my channel and are very knowledgeable on these subjects. But basically, if your immigrant spouse has entered the US legally or is able to enter the US legally, they might be eligible to adjust status in the United States if you are a US citizen spouse. Conversely, if they want to do the process abroad, whether they don't have a visa to enter the US or they're not already here, or you're not a US citizen, you're a permanent resident petitioning for them, or they have obligations abroad and they're not ready to move here yet and they don't mind how long it takes, they would do something called consular processing. When you enter the airport or any port of entry into the United States, and you enter with a non-immigrant visa, whether it's a tourist visa or student visa or some other type of visa that's designated as a non-immigrant visa. Like an H-1B is a dual intent visa, so it's not like a pure non-immigrant visa. You could have immigrant or non-immigrant intent. But if you have a tourist visa or student visa, for this example, during each entry, the customs officer at the port of entry must believe that your intent is to be here for a temporary period of time and then to leave. If you enter with the secret intent, in other words, with fraudulent intent to permanently live here as you're entering the US, that can create major problems down the road. And there might be a fraud determination, which ruins your whole opportunity to become a permanent resident because many people do not even qualify for a fraud waiver to get that fraud forgiven. So whenever you enter as a non-immigrant, you must have the intent of a non-immigrant. But sometimes people entered the US 10 years ago on a tourist visa and they overstayed. Those people may have entered with non-immigrant intent, but sometime thereafter, their intent changed, especially after they marry their US citizen spouse. Now, in this hypothetical, the answer clearly is apply for adjustment of status in the United States. If you leave the US, you'll trigger a 10-year bar and you won't be allowed back in this hypothetical where you've overstayed by more than a year and now you have more than 1 year of unlawful presence. You can't leave in that scenario until you've been granted advanced parole, which I don't even recommend applying for right now, or you have your permanent resident card. At that point, you could safely travel in most instances as long as there's no big problems like criminal history or fraud or some other stuff that, the Trump administration begins scrutinizing or creating problems. Let me give you a hypothetical that got me thinking a little bit. Let's say you're a US citizen and you have a fiance who has a tourist visa, and your fiance enters the US on their tourist visa, and their plan is to just visit you for 2 months and then go back to their home country. During these 2 months, they change their mind, whether you convince them to change their mind or they by themselves, doesn't matter, but they change their mind after they enter the US. But they're still on a valid tourist visa. In that situation, they can still travel in and out of the US without issues because they haven't violated the terms of their tourist visa. In that scenario, would I recommend marrying in the US or doing an international marriage, so that their entire family can attend and then coming back to the US? Well, if you marry in the US, I would not leave after that because during a subsequent entry, first of all, during a subsequent entry, you're probably going to have fraudulent intent. You'll have immigrant intent unless you purely are just getting married and then going back and then visiting and then going back. In that case, it's fine, but travel might be complicated if an immigration officer asks you what your plans are, and it becomes clear that you have a US citizen spouse, major red flag will go off, and that's going to result in many more questions about what your actual plans are in the US. Now, you might be able to get in. I've had many clients who are married to US citizens who continue to travel back and forth as tourists, but it's certainly way more complicated. And I've had people threatened by customs officers that we'll let you in this time, but next time you come, you better bring way more evidence that you're just coming to visit. For example, evidence that you have employment abroad, a residence abroad, obligations abroad, anything to prove that during your next entry, you're not here to permanently live here. The customs officers want you to do things through the consulate. They do not want you to enter as a non-immigrant and to apply for adjustment of status here for obvious reasons. Let's look at another hypothetical. Let's say you, the US citizen, are visiting your immigrant fiance in their home country. And while you're there, you guys have a big wedding planned, you guys get married. And your fiance has a tourist visa. And now they want to enter the US with you. And you guys try to enter together. And your actual plan is to enter the US and apply for adjustment of status in the future. That's a really bad plan. In case you're not seeing a theme here, the theme is don't leave the US, get married in the US, apply for adjustment of status in the US if you're eligible, and it's not going to create fraudulent intent issues. In this hypothetical, and I've seen this happen, when you enter the US, the customs officer, all they need to do is ask you, who are you going to be staying with? And then, you might give them some vague response like some family, which is technically true because you're going to be staying with your US citizen spouse. And if they say, like, what is their relationship to you? What is their address? Now you're kind of screwed because you're going to have to explain that they're your spouse and that they're a US citizen and this is their address. And once you explain that, the immigration officer is not going to allow you into the US unless you have an overwhelming amount of evidence that you're going to leave. Now, there are exceptions. I've seen people allowed in, but that's a really big risk to take just because you wanted to get married abroad. If you're going to get married abroad, the correct answer is consular process. And the only way you should ever be applying for adjustment of status in the US is if you entered with non-immigrant intent. Otherwise, there's a fraudulent intent issue and, it's going to result in your green card getting denied in the future if that ever comes to light or if immigration officers ever ask you about it, and you're supposed to disclose it on your green card application if you've ever engaged in any sort of immigration fraud. The big problem right now is, first of all, we're seeing processing times with adjustment of status beginning to creep up. I did another video recently about how USCIS's workforce is being substantially reduced and they're not even being allowed to do overtime work, and they're adding all of these procedures to just make the interviews take longer and for immigration benefits to slow down. But doing it at the consulate abroad is 10 times worse. The government is shutting down some of the consulates, gutting the resources at some of these consulates. So a consulate that may have had 100 employees might now only have 10. So it might have previously taken about a year for your interview to be scheduled after your case gets through the process and passes the National Visa Center and is ready to get scheduled for an interview. And now it might take several years. If anyone has a spouse in Bangladesh, they know that the cases that they filed in 2019 for their spouse are still pending 6 years later. That's not entirely because the government has cut the resources there. It's because so many people there are trying to immigrate to the United States. But it's going to be the same outcome when the US government cuts these resources at the US consulates in foreign countries. So all things equal, adjustment of status is my preferred option, but the big caveat is you must enter with non-immigrant intent. So just keep that in mind. All right, guys, that brings us to the end of today's video. I just wanted to do that quick topic because it was fresh in my mind and I thought maybe there's a few people out there who would appreciate it. If you're going through the family-based immigration process and you need any assistance, you could always reach out to me directly. My information for consultations is in the video description below. And if you're interested in learning more about immigration topics in the future, be sure to subscribe to my channel. I'll see you guys next time for another video.